bar.
Sure. Let the record reflect that you are a living man because dead man cannot speak. So, and I can hear you
It's fraudulent presumed anyways, though.
Right. So, this is people of the state of Michigan versus Eric and Martin. Today's date and time set for a pretrial in this matter. Are there any issues that need to be brought or raised before the court?
Excuse me if I may at first. Mr. Martin indicated he did not want me as his attorney, so I'm asking for permission to withdraw.
All right, I had, first off, Mr. Martin, I had previously appointed Mr. Gazicki as your house counsel. Mr. Gazicki has made a statement that you have indicated to him that you do not wish for him to be your attorney. Is that correct?
Yes, and not just him, any attorney, because I will not be allowing attorney to turn me over to the court, the jurisdictional court, which is what they do. This is why I don't set them normally.
All right. So you want to represent yourself, is what you're saying?
Not represent myself, but present myself.
Present yourself, represent yourself, same thing, sir. Again, we're not going to play semantics like you did the other day.
Yep.
So
the law is based on
it's the same thing, sir. It's the same thing, literally the same thing. Look at a thesaurus, present, represent, sure. So the motion is granted. You can withdraw, sir, Mr. Gazicki, and Mr. Martin, you'll be presenting and or representing yourself in this matter because you have a constitutional right to do so, and you can. So today's date and time set for a pretrial. So Ms. Sobe, you have not had the opportunity nor chance to speak with Mr. Martin, who is improper. Is that correct?
That's correct, Judge.
All right, so I'll allow the two of you. I will set this case over and I'll let
Judge,
you
if
two
I may,
discuss the matter in the hallway or in your office, and then I'll recall the case after you guys have had a chance to pre-trial the matter.
before we get into that, Judge,
Sure.
I do want to put on the record that my victim's advocate, Ms. Delisha, has been in contact with the complaining victim in this case at great length, and there is a no contact order. The victim is the brother of the defendant in this case, and he's notified us that he is still living in the same house. So the defendant and the victim are living in the same house, even though there's a no contact order. Further, the complaining witness has indicated to us that he's being threatened by the defendant in his own home, once again violating that no contact order.
Eric Martin is back, and somehow he's even more chaotic than the last time we saw him. Today he's standing before Judge Slovin, a judge who has absolutely zero tolerance for sovereign citizen theater, word games, or YouTube law philosophy. Eric isn't just fighting charges, he's fighting reality itself. He rejects lawyers, rejects jurisdiction, rejects common sense, and even rejects the very idea of understanding, because in his world, standing under words gives courts power over him. Meanwhile, this isn't some harmless traffic citation. Eric is facing fresh domestic violence charges, a no-contact order he allegedly ignored, and a victim who reportedly ended up in the hospital. And instead of focusing on the seriousness of all that, Eric is busy arguing about whether he represents himself or presents himself. In this hearing you're about to see, Judge Slovin tries, repeatedly, to steer Eric back toward reality while Eric keeps steering himself straight off a cliff of sovereign jargon. We've got bond violations, constitutional lectures, word salad objections, and one of the cleanest judicial smackdowns of fake legal logic you'll ever hear. Stick around, because things escalate fast, and by the end, you'll understand exactly why judges get gray hair. Let's get into it.
The complaining victim, to my knowledge, is in the hospital at this time. He's unable to zoom in, even though he wanted to be here.
He's in the check-in room right now.
He's been attempting to, but he is in the hospital, could not be here in person. He might have audio issues.
I think they're in the, I don't know what this thing is. I got Kurt Martin
Yes.
in the check-in room. So if you want to zoom back in or if you jump in back in on Zoom, Kurt Martin is in the check-in room right now.
Yes, the people just wanted to bring that to the court's attention, the multiple violations of the no contact order, the living in the house and the threatening and speaking to the complaining witness.
All right, so sir, are you still living in the same house with the victim?
I object to that question as violating my right against self-incrimination, so we'll not be answering that question based on that. And also I was going to object to her What she just mentioned, first I want to mention, allegations that I'm there, that's not sufficient evidence that I actually am there. And number
Well,
two,
I'll just have a bond hearing is what I'm saying.
well,
And then everybody will be sworn in and all that kind of stuff. Because I've already given you bond conditions. Part of those bond conditions was that there should be no contact with the victim. If you're living in the same house with the victim, you need to go somewhere else.
well, first of all, he ain't a true victim, that's something I'm object to, first of all.
First off, listen, I'm not even gonna entertain any of your stuff. This internet, Google the internet type stuff that isn't even real or true. All right, I've already ruled on most of your motions, and I'm gonna let you bring your motions again, and I'm gonna make rulings on them. But what I'm saying is, you don't have a choice in the matter. I gave you bond conditions. They're alleging that you violated the bond conditions. So under the Constitution, I can't just say, oh, you're in violation. No, I need to have a bond violation hearing. And if you are in violation of my bond conditions, then I can hold you in contempt. If you're not, then you're not, and the case just goes forward. It's as simple as that. It's called due process. So what I'm saying is, when she says you object, when you say you object to the alleged violations that she's alleging, listen, you don't even get a chance to object to that. That's their job that's their job to bring those. And if they're correct, they're correct. If they're not correct, you have the right to have a bond hearing. And at that bond hearing, if it gets proven by preponderance of the evidence that it is true that you violated my bond conditions, then I will proceed accordingly. And if not, then the case will just go forward and you'll still have all your constitutional rights. So what I'm saying is your objection is overruled because there is no objection that can be made to allegations, because that's all they are, is allegations.
So objection made based on the Constitution. There's no sufficient evidence that he lied.
This is the moment everything shifts from funny to serious. Up until now, Eric's antics might sound like typical sovereign citizen comedy, refusing lawyers and arguing semantics. But now the prosecution drops the bomb. The alleged victim is Eric's own brother. There's a court-ordered no-contact order, and Eric is allegedly still living in the same house with him. Not only that, the brother reports being threatened inside his own home. That's not paperwork confusion. That's not jurisdiction theory. That's real-world danger. Judges treat no-contact violations extremely seriously because they exist to prevent exactly this kind of escalation. And with the victim now reportedly in the hospital and unable to attend, the emotional tension in the room jumps instantly. What was once wordplay now becomes a question of safety, consequences, and whether Eric truly believes the law doesn't apply to him, even when someone else is getting hurt.
This whole case
Sure,
is
you're
based on him
testifying. You're
lying.
not going to testify. You're not going to testify. When you get your, listen,
Issue.
you're not going to testify. If you want to testify at your bond violation hearing, you can do so, or you have the right to remain silent. Anything you say can and will be used against you. So what I'm saying is, the only reason I'm cutting you off because I don't want you to step on your own constitutional toes. Everything you're saying could be used against you. So I don't want you to say something that you didn't mean to say, and then all of a sudden, then they get to use that against you, because that's your right to remain silent. You understand that, right? You understand what I'm saying? Okay, I'll take your silence. I'll take your silence as an affirmative.
No.
So, well, you didn't say that you didn't understand. So
No, I do not understand.
you don't
I do
understand.
not stand under with anything you're saying, so, but anyways, this
That
is all
doesn't-
this
that
discussion
doesn't
for
make
emotions.
sense from an English standpoint. You're not standing under anything. I didn't build a bridge. I
Well,
didn't build a
legally,
roof.
it's not all
I
based
didn't
on.
put up an umbrella. I didn't put up a canopy. I didn't put up any kind of other item that you could stand under, a ladder, you name it. So there's nothing that I've said that you can stand under. But what I am saying is you do have the right to remain silent. And anything you say can and will be used against you at trial. So that being said, I'll let you go into the hallway. You can meet with Ms. Sobe and have a pretrial in this matter. And then we'll deal with after the Kurt talks with the victim advocate, and then you talk with the victim advocate. We'll decide when we're going to have the violation of the bond condition hearing.
Thank you, Judge.
So Slade, I'll remind you, this case is scheduled for a motions hearing, and
So the two of you can go out and have your pretrial.
my demand.
I just told you go out and have a hallway, have pretrial. If you don't want to talk to her, then don't talk to her. That's up to you. But what I'm saying is right now.
Talk to her, okay, I'll talk to her, what I'm saying, but right
Just
now, I have these.
Sure, you're not
demands.
controlling these proceedings. I said, right now is the time for you and Ms. Sobe to have a pretrial. If you're gonna have a pretrial, we'll do that. I'll control when cases get called in front of my court. Thank you very much.
It's obvious Judge Slavin has reached his limit with Eric Martin and his nonstop sovereign citizen theatrics. After that little exchange, Eric and the prosecutor step outside for their pretrial conference, which, unsurprisingly, goes absolutely nowhere. The moment they walk back into the courtroom, they jump straight into yet another argument, this time over jurisdiction. Because of course they do. With Eric, it always circles back to the same tired script.
Watch what Eric does next. When the judge simply asks if he's still living with the victim, Eric instantly objects on the grounds of self-incrimination. Now here's the thing. Invoking the Fifth Amendment is absolutely a right, but Eric isn't using it strategically. He's using it as a shield against any question that might corner him into reality. The judge isn't asking for a confession to the underlying crime. He's confirming compliance with bond terms. Courts take bond conditions seriously because they are the reason a defendant is allowed to remain free while awaiting trial. If you violate them, the privilege disappears fast. Instead of answering, Eric pivots to arguing that allegations aren't evidence, completely missing that the judge is literally offering him a bond violation hearing to determine exactly that. Eric thinks he's outsmarting the system. In reality, he's talking himself closer to contempt.
Dismiss the case for lack of jurisdiction is denied. 1, you live in Taylor. 2, you allegedly committed a crime in Taylor. 3, the complaint was filed here in Taylor and was sworn to here in Taylor. So under that Constitution, you have availed yourself of the jurisdiction. You live in Taylor. You enjoy all the protections of the police department, the fire department, garbage services, you name it. You have more than adequate minimum contacts with the jurisdiction, and I find that your motion has no merit. It is denied.
I don't object to that. As my argument, Article 3, Section 2 of the U.S. Constitution, that's totally irrelevant to when a state's a party. This court doesn't have original jurisdiction, or the U.S. Supreme Court has original jurisdiction on Article 3, Section 2, and Article 3, Section 2 doesn't allow them as reasons to deny or to say that you do have jurisdiction. They do not allow it.
Sure, Article 3, Section 2. Again, your motion is denied. Article 3, Section 2 of the United States Constitution deals with when one state sues another state. And that's like trash cases like New York versus New Jersey, things like that. But they have original jurisdiction over those cases. This is the state of Michigan versus an individual who lives here in Michigan, and that's you. And so living man, living trust, living Stewie, whatever you want to call yourself, guy, big E, little G, I don't know, whatever, all that good stuff, big M. None of that makes any sense, nor does it make any difference legally. The fact that I have little yellow tassels around the flag over here, that doesn't change anything either. This is the United States. Sure, keep on mumbling. This is the United States. This is Taylor. You live in Taylor. You committed a crime allegedly in Taylor. So the case is going to start here in Taylor. And so that's why I have jurisdiction over you for the reasons stated on the record and just the obvious the United States Constitution and Michigan Constitution. I have jurisdiction over this case. So that motion is denied.
This section is actually a masterclass in patience. Judge Slovin carefully walks Eric through exactly how due process works. Allegations are raised, a bond hearing is held, evidence is weighed, and only then are consequences imposed. In other words, the judge is protecting Eric's rights, even while Eric insists the court has none. But Eric is so locked into his sovereign citizen worldview that he tries to object to the very existence of allegations, which isn't how court works anywhere on earth. The judge finally shuts it down. There's nothing to object to yet because nothing has been ruled on. It's like Eric wants to argue with gravity while falling off a roof. The court isn't his enemy here. His refusal to listen is.
With regard to bond conditions, your motion to stay or set aside or dismiss the bond conditions is denied. The Michigan court rules, which are set forth by the Michigan Supreme Court, are the ones who specifically state that I can set bond conditions in order to do a couple of things. 1, to make sure that you appear at court. 2, to make sure that there's a difference between the parties or allegations of violence against the parties or between the parties, that I can keep the two parties separated in time. So you need to be not living in the same place as the victim in this matter. Now, at the bond hearing, I'm going to set a bond hearing for the alleged violations of that bond hearing. Because one of the things I need to know is who owns the house, like legally owns the house. Because I'm a big proponent of property rights, and that was one of the biggest things that we moved over here and created a constitution and why property rights, and you can't just take people's property and all that kind of good stuff. So somebody's going to be moving out in the meantime during the trial. I don't know if it's you or if it's a victim. Whoever actually owns, like owns the house. I'm not going to order somebody to move out of their own house and let a victim or alleged victim stay in a house that they don't even own. The victim will move. That's how that's going to work. So if you want to check with the victims and see who actually owns
To
the
my
house.
knowledge, I believe it is the mother's house,
Okay.
and they are brothers,
And the mother is still
with-
alive?
to my knowledge.
Okay.
Is she alive?
You talking about my sister, Lisa Martin? No, she always speaks Spanish. She owns it. She don't own nothing.
Who owns the home?
Well,
I'll
this
just
is the thing,
look up the Wayne County Register of Deeds. Counsel, just make sure you just do a search in the Wayne County Register of Deeds, find out who owns the home.
Well, under adverse, non-adverse possession law, because I've been living there a minimum of 15 years under that state statute.
No, you see, again,
I am-
listen,
Pardon.
you just have no law, I literally teach it to you. So just telling you, you're wrong, because you can't have adverse possession with permission. If you have permissive use of the property, you'll never, ever, ever gonna get adverse possession.
Adverse or non-adverse, okay?
Okay, there is no non-adverse, trust me. I don't remember that one ever being on the bar exam. You know what, hey, whatever bar exam you wanna take, you let me know. I'll study for that one too, and I'll take that one.
Here we get one of the classic sovereign citizen trademarks, turning normal English into a battlefield. Eric claims he doesn't understand, but not because he's confused, because in sovereign law, understand means stand under authority. So he announces that he stands under nothing. Judge Slovin responds in the best possible way, by taking him literally and joking about ladders, umbrellas, and bridges. It's funny, but it also exposes the problem. Eric is trying to win a criminal case through linguistic gymnastics instead of evidence, law, or logic. Judges don't lose jurisdiction because you redefine words mid-hearing. All Eric manages to do is convince the court that is less interested in defending himself and more interested in performing his own private legal philosophy claim.
But
So-
to answer your question, let me finish saying, you always want to try to cut.
No, because I want to wait till everybody's under
Being
oath.
fair.
I'm just saying, I'm staying at the hearing. I want to know legally who owns the property.
I was going to mention, no, we can do that too. I'm just saying, but it's always,
Oh, we're not ready to do that now
Parents' house.
today.
Justin, it was always my parents, right? House, so to say, and I don't even think they really owned it because the mortgage wasn't paid off. So I don't think really, no one totally
A
owns it.
mortgage
They
is just a
pay.
promise to pay money. It has nothing to do with actual ownership. Ownership and mortgage are two different things.
I think actually, all of us at the house are possessors of law. My understanding of law is we're actually possessors. Because the bank really owns, because the mortgage was never paid off, from my understanding. But it was always, so to say, our parents' house. Like I said, I don't think they really owned it. 'cause-
Sure, here's what I'm gonna do. I'm just gonna go ahead and sua sponte, look it up in the Wayne County Register of Deeds myself, because it's a matter of public knowledge. And then I'll take judicial notice of the fact who's the owner.
Like I said,
That's all I gotta do.
adverse and non-adverse possession, MCL
So-
statute.
What we're gonna do is we're gonna have a hearing date. And that hearing date, it's gonna be on the same date as the jury trial. So in the meantime,
I have a right to be there though, because I've been there minimum
didn't say
15
you,
years.
I
By
mean,
state
you don't have a
statute.
right to be there, so you don't own the
Sure.
property. You don't own the property.
Under that statute, I am.
You don't own the property. So you need to vacate the premises, because that's where the victim lives. I told you, no contact with the victim.
And that's an unlawful void order because it violates.
But it's not, because I
Because
just
without
said.
any evidence, you can't just say, I can't be
Okay,
at a
so,
house.
listen, sir, I'm gonna tell you one more time. I'm not gonna sit here and argue with you. If you keep arguing with me in court here, I'm gonna hold you in contempt, because you're just holding up everybody else who's ready to go and proceed with their cases. And you just keep bringing up the same thing that isn't anything at all to bring up. I've already rated my ruling on your motion, I've denied your motion. I told you that you can't live in the same house with the victim on a domestic violence case, when I told you you have no contact with the victim. And if you don't own the house, now if you own the house, like actually own the house, like show me the deed that shows that you are the Wayne County Register of Deeds, that you're the owner, I'll make the victim move. Why? Because I'm not gonna kick somebody out of their own house. I'll make somebody will move, but it ain't gonna be you then. But you don't own the house. Okay, so, you're gonna need
And I
to
have
vacate the
objections to
premises.
that. I have
You're gonna need to
objections that.
vacate the premises.
Okay, and I objected, like I said, it's not just a deed whether someone owns it. Under the statute in Michigan, it mentions.
First off, what statute? Cite the statute.
Okay, I don't have it right in here because I was going to grace, but I'll give you the statute. You already know me. I cite MCLs all, I no problem. So I'm gonna give the MCL statute, but it deals with what's called not adverse or adverse possession, okay? So when you live,
Well aware.
one of the basic elements, you lived at a house for 15 years, right? Remember, this is my parents' house, right? I've been there 30-something years. When you lived in a house that long, you are considered part owner of these, you know? So, and you therefore a right to be living at that house.
On cue. Here we go again. Jurisdiction. For sovereign citizens, no jurisdiction is like a universal remote control. They think it turns off any courtroom in America. Eric argues federal constitutional provisions meant for disputes between states, while his own case involved a local criminal charge in the city where he lives. Judge Slovin dismantles it point by point. You live here, you were charged here, the complaint was filed here. That's called minimum contacts and territorial jurisdiction. Eric isn't citing secret law, his misreading public law, but instead of adjusting course, he doubles down, convinced that if he says living man and Article 3 enough times, the case disappears. Spoiler, it doesn't.
No.
So it ain't just whether you have a deed or not.
No.
That's, and regardless of the ownership,
No.
yes.
No.
No, okay.
You have a
MCL statute
possessory,
on the site.
after 30 days, if you stay in a premises with permission, after 30 days, you become a de facto month-to-month leaser. And you become a leasee at that point, and you have a lease with the property. That's it, at best. And that means you can stay there and they can evict you, or I can give you a bond order that says you need to vacate the premises.
Yes, if
That's a
someone
court order.
owns it, maybe, yeah, but
You don't own it. You don't get possessory interest, but you don't get an ownership interest. There's an
no,
absolute difference.
no one owns it.
There's an absolute difference. Listen, you're not gonna argue with me. Keep arguing with me, and I'm gonna hold you in contempt. Because I'm telling you, you don't own the property. You have a possessory interest at best, because you've been there for 30 days, sure. And they can either evict you, or a bond condition can move you out. Either one. Or actually an injunction from the circuit court for if there was a case, they have the power to move you out of there as well. There's 3 different scenarios where you could be moved out of there. One of them is bond condition. Bond condition says no contact with the victim. You don't own the house, get out. In the meantime, get out until the case is done. So if I find or know that you are there, I'm just telling you, I will hold you in contempt of court. I will remind you that contempt of court is a misdemeanor punishable by 90 days in jail and or up to $1,000 in fines. And I'm just gonna let you make sure that you are aware of that. Again, ask you, would you like any court-appointed attorney to help you in this case?
No.
Okay,
I have
just
more
double
to say
checking.
now. And
Just
it's
double
like you
checking.
said, part of my constitutional rights.
Just
Now,
double checking.
The order,
Right,
first of
so-
all, the bond order violates my due process because you can't tell me to be out of the house, my house I've been living in all my life.
It is because it's not your house. You keep saying your house and it's not your house. It's the place that you were allowed to stay by your mom and daddy. But now they're no longer, this is not that situation anymore.
The
It's
statute
not that
does.
situation anymore. So you don't own the house.
Let me clarify.
You're all grown up now and you don't own the house.